Welcome to Conveyancing Matters. Stu and I are going to ask the question, has everyone lost sight of the contract? Welcome to Conveyancing Matters with Lorraine and Stu. Join us for a chat about all things property. So, Stu, how are you, mate?
I'm very good, Lorraine. How are you?
Yeah, I'm good, thank you. Probably better than a lot of law firms at the moment. We don't normally give the date of these chats, but today's the 28th of November 2023, and on the 24th of November 2023, we started to get sort of trickling of information that another large cloud-based sort of software provider that supports lots of law firms had a cyber attack. And was affecting lots of law firms and their ability to complete. And Stu, you posed what I think is a brilliant question. You know, has everyone lost sight of the contract? So what did you mean by that, Stu, when we were talking off air?
Well, it's all the sort of all the fuzz that's around this. And what do we do? You know, do we be nice to everybody? Do we, advise our clients this, that, and the other? But to me, it's, you don't need to do anything. It all comes down to that contractual arrangement between the buyer and the seller and our role within it. And that is to advise our clients, be that, the client that we're talking to that's moving house or the mortgage lender.
Yeah, absolutely. So, the first thing to say is A, we never name names, and B, hopefully, Stu, we never gloat and we don't point fingers. And of course, it's absolutely fair to say that every affected firm, every affected conveyancer in the firm, and every affected client, we'd have a lot of sympathy with, inevitably. And as with any cyber risk thing, we've always said, Stu, there but for the grace of God go we. It could happen to anyone, couldn't it? But I think
it won't be the last, will it?
Absolutely not.
It won't be the last. So again, I think hopefully this chat may be helpful in terms of if anything does happen in the future, maybe everyone's aware of what they should be doing. But it's so unfortunate, and you just would not want to be in those law firm shoes at the moment, and dealing with this is obviously an absolute nightmare. So my deepest sympathies do go out to them.
However, we don't seem to have had much in the way of sort of concrete information, or frankly, dare I say, much sort of sense really from people perhaps posting on social media. And I think one of the slight sort of things that could be misinterpreted is a lot of the commentary going around saying, oh, conveyancers, everybody's got to be kind. Well, we have got to be kind to each other. And as you and I chatted off air, Stu, we've got to be professional with our conveyancing colleagues. And if you're on the other side of a transaction that can't complete because of difficulty in a firm, you and your staff have got to maintain your professionalism.
Of course.
But that seems to be being the be kind mantra suddenly seems to be being sort of interpreted as, oh, well, kind of none of this matters, and let's be nice to the clients, and let's not worry about the legal framework that this sits in, and everything will come out in the wash. And I simply can't get hold of that idea, Stu. Can you?
No, I completely agree with you. It's not a case of being horrible or kind. It's a case of, what you're here to do. And I think, we would all be sort of, ridiculously silly if we all thought that, this might never happen to us one day. We could all be targets. We probably all are targets. We all use tech to some degree. So we all, we're all going to be targeted at some point. But for me, it's it's recognizing what's happened. It's having empathy, with those law firms. But equally, you've got to tell your client what's happened, what the situation is. And there's also been a lot of criticism of some of these firms in terms of, what's been publicly revealed. But, I'm sure if this happened to us, the first thing we would do is probably contact our indemnity insurers. I'm sure their party line would be saying nothing. And therefore, it's not as easy, I think, as a lot of people think, that you just come out there, release a statement, so on and so forth. And those firms are probably sitting there not knowing, A, when things are going to be sorted, and B, they're probably not allowed to, under the terms of their insurance, reveal too much. So in terms of what then happens to us, i.e. if we're acting for a client, we're on the other side, we've just got to simply tell that client as it is, and let them make the decisions of what they want to do. They've already entered into a contract. Obviously, if you're doing a simultaneous exchange and completion, you're not going to move forward with it in the immediate, unless the client, of course, actually tells you to. But always bearing in mind you've got two clients, the bank as well. But your job is to advise the client when things go wrong, what their position is under the terms of the contract. And that's no different, really, is it, to somebody maybe, having a situation where a vendor refuses to move out, or, we had them before where you ring up a buyer on the day and they've, overslept and, can I not do it today, or something ridiculous. Your job is to advise the client under the terms of the contract, the implications to the situation and what they can and can't do, and let them make the decision.
Yeah, I think that the interesting thing is that in many ways, I mean, the contract incorporating the standard conditions of sale, it's got lots of small print. It can seem quite harsh in its application, but the great advantage of that contract is it does have clarity. All the parties, the contracting parties, the buyer and the seller, know where they stand, and what the contract does is I've always described it as giving the contracting parties a second bite at the cherry. If the matter doesn't complete, then there is everybody gets another go. And I'll perhaps come on to that in a minute. But I think, Stu, the reality of this is, I think, given the clarity of that contract, actually the reason for the matter not completing is largely irrelevant.
Yes.
Between the buyer and the seller.
Yeah.
At the moment, we happen to have something as we had 2 years ago, and we'll talk about that in a minute. But we have a situation where 80 to 100 reportedly firms are affected by this cyber attack that's affecting their systems, and meaning they can't proceed because they can't get into their systems, presumably, and transact and do their daily work. But in fact, so we notice it and we know about it because it's a large sort of systemic issue. But the reality is, as between individual buyers and sellers, the actual reason for the matter not proceeding is, I think, irrelevant.
Yeah.
As you've said, there is a buyer and a seller. They have entered into a binding contract that has terms and conditions. And of course, as you mentioned in passing a moment ago, Stu, what people seem to forget time and time again in these situations is that the lender is also a client. And we have talked about this now and under our subscriptions webinars. But if a seller cannot redeem a mortgage on the day of completion, then the buyer cannot and should not be moving in.
Of course. It's the whole fundamental sort of foundation of conveyancing, isn't it? Under the protocol, if you can't give that undertaking that the mortgage is going to be redeemed on the day that the money is sent over, then you can't move forward. It's this is in my mind, it's no different to, I think it was 3 to 4 years ago. I can't remember. I'm sure it's 3 to 4 years ago. I definitely know it was a Friday. The only reason I know it's a Friday, it's the first year we ever had our Christmas party on a Friday as opposed to a Saturday. And Barclays went. That's right. And I'm sure they were down for the majority of the day, or certainly to the late afternoon. And most of our fee earners were then, of course, locked in the office till 7, 8 o'clock at night. Trying to get these balance of completions done on various means, whether it's undertakings or whatever the case may be. But it's no different to that. There could be a multitude of reasons as to why a completion might not take place. And of course, if it is lawyer related, well, then there is a retainer between the client and the lawyer, and that's for the client and the lawyer to sort out in terms of whether there's a situation where costs might be covered by the lawyer, who knows, but that's for that client and that lawyer to sort out. Your position is purely your client, whether your client suffers any loss, and implementing that under the terms of the contract. And it's like when we talk about serving notice, there seems to be such a urge at the moment in the profession that as soon as 2 o'clock comes, if we've not completed, we're going to serve notice, make time of the essence. But sometimes I think, well, do your client definitely want time to be the essence here? This is a commercial transaction where you're getting a decent value here. You're actually sure you want your client to have
exactly? I think people fail to understand, Stu, that the serving party can't withdraw it.
No, exactly. So have you spoken to your client and got clear instructions that they want you to serve the notice? Because I would guess that most, a large proportion certainly,
Yeah,
maybe don't.
And I would say all of the affected firms with the current cyber attack situation, they're not in a position to serve a notice to complete because they're not ready, able, and willing to complete. So, they're
had this exact debate only last week, ironically. Who's ready and able here. But sometimes I think we get so caught up in this process, and it becomes an automatic thing that people think that they have to do. Well, actually, no, you don't have to serve notice in the slightest.
No, I don't.
No.
And well, I mean, I am struck...
that maybe that's the link to being kind, isn't it? But it shouldn't be being kind. It shouldn't be an automatic thing to serve the notice. It should be your client's instruction to do so.
I think that's the point. And as I say, I absolutely subscribe to be kind, as in be client, be professional, be reasonable. But fundamentally, everybody can't just be sort of either moving or ignoring contractual responsibilities on behalf of their client, because lots of firms are affected. I'm sorry, I just don't go with that one at all. That's, the standard conditions of sale are there to give us clarity. Now, if the clients want to, give the party on the other side of their contract some leeway because they accept that a systemic IT failure in the conveyancing process is not the fault of the party on the other side, that is fine. That is for your client to instruct you accordingly. And you might be saying to your client, look, love, this is a fait accompli. This, you've got a bit of a Hobson's choice here. We don't think we can complete, but it's not the other party's contracting party's fault. Do you want to sort of essentially waive some of your contractual entitlements or not, or I think what a responsible firm would be doing is saying, or shall we just wait and see?
Of course. Well, don't forget, at the point when this broke on Friday, we didn't know at what point it was going to rumble on. As far as we were concerned, it might have been resolved in the afternoon. So I think there has been a bit of a knee-jerk reaction, and also as well, I've heard various people talk about clients' damages and stuff like that, and I'm thinking, crikey, come on, a client's got to mitigate their damages here. This is not somewhere where they can just write a list of costs and automatically claiming back here. There is an obligation on the client to mitigate those costs. So there are certain circumstances where actually, completing, maybe a day later or weekend over a week, over the weekend on the Monday might not be the end of the world to them.
But if these transactions, it's reportedly, the current attacks reportedly affected 80 to 100 firms. Mm-hmm. The affected firm put out one short statement on its website on the 24th, and I can't see that it's updated it since. So, Stu, for practical purposes, and certainly for next time, if you're on the other side of a transaction, you're not affected, and you have a completion, because you raised a very good point at the beginning, at the time these news sort of stories break. Of course, you don't know who's on the other side and what their situation is and whether they're an affected firm. So, what do you do to protect your client and frankly, your firm to some degree, Stu?
Yeah, well, you've got this balance, haven't you? Number one, you've got to ensure that your client, in accordance with the instructions you receive, fulfill their obligations under the terms of the contract. And of course, that means sending the purchase monies to the seller's lawyers if you're acting on a purchase. So, there is always a balance. Because if you know that there is a possibility that a firm may be affected, then you need to clarify that. A quick email in writing to get a statement that you're going to rely on. So it's effectively an implied undertaking. Would suffice. There isn't, we haven't got a crystal ball here. And you do still need to be mindful that you can't willy-nilly withhold monies because your client's then in breach. So, there is, a case of just doing the best you can, but covering your back by getting a statement from the other side to simply say that they're not affected and they can comply with the undertakings that they've given.
Well, complying with the undertakings, Stu. Now, as I say, we won't name any names, but you did say off air something that I found quite startling, really, because you said you spoke to someone high up in one of the affected firms about, frankly, one of the most basic and central issues in any conveyancing transaction, that of the undertaking by the seller's conveyancer. So just tell me that story without naming any names, because I found it quite shocking.
Yeah, well, first of all, obviously, I do have massive empathy for the firms that are affected, so I don't want to sort of be too critical. However, I did have one conversation, and it was a senior person at a particular firm that said we were being difficult in not sending the balance to complete. And the reason that we hadn't sent the balance to complete is A, we'd spoken to our client, firstly, but B, the reason we'd spoken to our client is that the firm couldn't carry out the terms of the undertaking given in terms of redeeming the mortgage, and couldn't give any kind of clarity on when that would be. So quite clearly, we couldn't send them the money without knowing that the mortgage would be redeemed. And who knows, maybe a week, a month, a year, who knows? So quite incredible to think that somebody would think that we would send it on that basis. But
so you asked them the direct question, can you give me an undertaking or confirm your previously given undertaking that you can redeem the mortgage today? And what did they say?
No, we can't confirm it. It's unlikely we'll be able to redeem it today, but we still want to complete. And the undertaking will be modified to say that we will redeem the mortgage when we can.
And they thought you were being unreasonable for not completing on that basis. I find that extraordinary.
No,
I really do. Actually, I find it absolutely extraordinary.
Yeah, I must say to put a bit of meat on the bones. We had similar conversations with others in the same firm, and there were different answers to that question, and others did treat it differently. So I'm not saying it's a firm's policy or anything like that.
No.
However, once you know that undertaking has been revoked and modified, and we've spoken about undertakings and the accuracy of them, you're going to be very mindful that it's the kind of fundamental part of a completion, isn't it? That if you send purchase monies to a seller's lawyer, they're going to redeem the mortgage on that day. So
well, and of course, we do have that broader point, don't we? That broader file management point, that in the melee of these difficulties, Stu, our file must be an accurate record of what was said. And in the heat of these very difficult situations, I wonder whether conversations are being properly noted, whether
I'll tell you what, it's a really important point, this, isn't it? Because what you are entering into is the possibility of people suffering a loss. And if we enter into the realm of people suffering a loss, any kind of inaccuracy on either side, making sure that all of this is covered off in writing is obviously of the utmost importance, as I'm sure you would anyway, but even more so in this kind of circumstance where what you do may be relied upon.
Yeah, absolutely. And of course, Stu, and we talked about all of this off air, didn't we? Which is why we decided to do a chat about it on air. But Stu, perhaps what I thought, I'm no great conspiracy theorist, but everyone will remember again a similarly probably more dramatic sort of systemic problem within conveyancing from another big sort of provider organization 2 years ago, November 2021, another cyber attack. And I asked you, is that a coincidence? And what did you say that I thought was really interesting?
Well, is it a coincidence that it all sort of centers around that Black Friday kind of vibe?
Yeah, you do wonder
on a Friday. I think what it goes to show you is that the fraudsters, and we all know this, we all go on about it, we all talk about it, we're all a target, aren't we? But everybody involved in the conveyancing chain is a target in some way. So those that think it may never happen to us, you're talking some of the biggest conveyancing outfits in the UK have been attacked, and they've suffered. So we are all, to a certain extent, and to coin a phrase, we're all sitting ducks at the moment. And to think it will never ever happen to us, well, of course, that's silly. It could happen to anybody at any point. And again, making sure that your policies, procedures in terms of cyber attack, your business continuity plan, and of course cyber insurance as well, making sure that all these things are up to date and regularly looked at.
Yeah, absolutely. As I say, as somebody who's very old at the weekend, as it happens, even older, of course, one can't turn back the prop tech clock, but of course you do. You just said there, you know, we're all under attack all the time, and I do worry, you know, and one of the testimonials on the current affected firm's website says, you know, in an era of increased data and connectivity, secure business continuity has never been more important. Knowing our data is secured, stored in a secure location and available to us quickly is a big weight off our mind. We will never lose more than 30 minutes of data. You know, we can tackle any eventuality and be secure in the knowledge that we can meet our clients' needs at all times. Shall I tell you what this teaches me? It teaches me that organisations giving other organisations glowing testimonials need to just be a little bit more careful and perhaps a little bit more circumspect about what they say, because this sort of thing can absolutely come and bite you in the backside, can't it, really?
Well, of course it can. Look, we're all a crystal ball as well. Just one other point as well, CLC firms especially. I was at the London Roadshow, was it last week, week before, and they did one of the sections on their roadshow was about cyber fraud and cyber attacks, and there was some really useful information that they gave out. So CLC firms definitely contact the CLC in general for some of those notes, because there was some really good information in there. And I forgot the name's chap, the name of the chap that gave the lecture, unfortunately, so bad on my part, but I have to admit he was very good. And what I liked about this chat is it was specific for law firms. It was not a generalized talk on cyber attacks. It was very generalized on law firms. So I actually found it very useful, and we came away with a few ideas and a few things we were going to tweak. So definitely well worth asking the CLC for those notes. I'm sure they said they were going to release those after the last roadshow that they're holding as well.
Oh, excellent. Well, thanks for that, Stu. Well, perhaps then we'll bring this slightly impromptu chat to a close, but you know, we do send out our sympathies to the clients and affected firms, and particularly the conveyancers on the front line, because they're actually picking up the pieces. But I think the reality of it is, you know, we posed a question at the beginning of this, you know, has this latest cyber attack caused a lot of property lawyers to lose sight of the contract? And I think the answer to that sadly might be yes, and they perhaps need to be refocusing on, you know, as you keep saying, the fact that the sellers and the buyers have entered into a binding contract.
Well, there's nothing the lawyer at the front end can do about this, whether they're the one at the firm that's affected, whether they're the one that's acting with the client that's not. You can't alter what's happened. And therefore, the only thing you can do is properly advise your client about the contractual relationship that they've entered into and the implications of the event and what it means to them. That's all you can do.
Excellent. Well, thanks very much for your thoughts on that, Stu. Very salient and hugely relevant right now. So thanks for that, lovely, and I'll see you soon.
Take care.
And you.